Okay, good morning, everyone. Sorry for the delay. So before we start, I just quickly want to address an error I made. I had a member reach out to me to ask to reschedule a bill. Trying to think of the bill number off the top of my head, I thought of the wrong bill. So it was my error. So I rescheduled HB 1431 when I meant to reschedule HB 1278. So HB 1431 will be heard end of day, February 8th, as well as the time to be determined on February 8th for HB 1278. I want to assure everyone there was nothing nefarious going on. It was simply an error. So, with that said, I'm going to open the public hearing on HB 1364 and call up Representative Mary Jane Wallner. Oh, I don't see, is Representative McWilliams not here? Are you, oh, so you're gonna introduce the bill for her? Could you? Cause I don't see her here.
I'm Representative Mary Jane Wallner, and I'm from Concord. You're right, almost in my ward, so you're just a street away from me. So, um, glad to introduce this bill today. I am a co-sponsor, and what it sets up is a commission to take a look at the way we deal with child care appeals. This looks at setting up a commission just to study it. And I think it's a great idea to take a look at something new, a new way of doing appeals. And I think this would give us the opportunity to take a look at what other states are doing. We've been doing it this way. I think I was a child care provider for about 50 years. And I think we've been doing it the same way for about 50 years. So this would just give us the opportunity to take a look at some new ways and some different ways of dealing with appeals for child care providers. I'm willing to answer any questions.
So I have a question. Was this not included, because I know there was a few years ago, because I remember Representative McWilliams coming before us before with a bunch of child care bills, and we did hear a lot about the appeals process and the violations that were going on, and people felt there was just some, I can't think of the word, but you know, that it was really impeding the business and causing problems for the child care centers and to be even to stay open and take children. Was this not something that was studied during that? Do you know?
Representative McWilliams can probably answer that better for you. She has introduced a number of child care bills in the last couple of sessions, and some pieces of those bills have actually passed, and other pieces have not. They've been amended. The interesting thing was I was surprised when I looked to see that this was coming to children and family, because the other bills have been going to ED&A, and you're correct that they have done spent a lot of time looking at child care licensing and the issues around licensing issues. So I was surprised it was here.
So was I.
Okay.
Are there any other questions? All right, seeing none, thank you so much.
Nice to see all of you.
Nice to see you. So, up next is, I apologize, I cannot read this name. Is it Marianne Baxter? Barter, from the Child Care Advisory Council to speak in support of the bill. It's okay.
My name is Marianne Barter. I'm the Executive Director at Merrimack Valley Daycare Service, and I'm the Chair of the New
Is the mic on?
Oh, there we go.
There you
Okay.
go.
Hi, my name is Mary Ann Barter. I'm the Executive Director at Merrimack Valley Daycare Service, and I'm the Chair of the New Hampshire Child Care Advisory Council, and I'm in support of this bill. And I believe I can answer the question that you had for Representative Wallner. When Rebecca McWilliams put together the bill and different issues were being studied, this bill came out of that. So something that came up was an idea of looking at the appeals process to make it more fair or equitable for providers. And so currently the appeals process that exists for New Hampshire is that if you are given a violation from child care licensing, you would appeal back to child care licensing. And although we don't question their integrity, they're wonderful people and we consider them important allies in our work, caring for children, it does create an atmosphere where a provider could feel like there's no point in appealing a decision because they can't win. And whether that's true or not, I don't know, and I have not studied the data, but it does create that situation. So we feel like this will improve the relationship between providers and childcare and the Child Care Licensing Bureau. Any questions?
Are there any questions? I would just like to say that that is exactly the testimony we heard a few years ago when some of these bills were in front of us from child care providers. So thank you for stating it so eloquently.
Thank you.
All right, thanks so much. And then up next is Melissa Clement from DHHS Child Care Licensing Unit is here to answer questions. Did you want to testify? Can I ask you a couple of questions and anybody else that has, I'm sorry.
Good morning, thank you. I'm Melissa Clement. I'm the Chief of the Child Care Licensing Unit in the Department of Health and Human Services. And we're not taking a position on the bill, but we're very happy to have the issues studied so we can find better ways of doing our work. We're always happy to do that.
So I guess one of my questions would be, do you find that the appeals process could be impeding on child care opportunities for parents, right? So if these facilities, say, lose their license for a certain amount of time or while trying to do the appeal process, or how costly it is for child care facilities and that cost is then passed on to families, would that make it more difficult for families in this state to get child care?
So let me walk you through. We have two different appeals process. So there is an administrative appeals process, which is what happens when an enforcement action is taken on a license, which would be we've chosen to fine a program based on the citations that were found, or maybe we've had to do a conditional license or revoke their license or suspended their license. That's a separate process that happens through the Administrative Appeals Unit at DHHS. This commission, my understanding, is to study our what is called an informal dispute resolution process. And that process is if a program is in violation or we've cited them for certain violations, and when they see the evidence that we've presented on a statement of findings and they feel that they are actually in compliance with that rule and they want to present their information to show that, we call that an informal dispute resolution process. So that is when they make a request to the department for that process, and then we look at the information and determine whether they were in compliance at the time. Maybe we didn't have all the information we needed, or that we made some errors maybe in some of our evidence, but the overall violation might stand, or that we've removed the citation remains as is because what they presented doesn't change the citation. So that is the process, I believe, that is meant to be studied under this commission. So it doesn't impact their ability to operate. That would only come through one of those administrative actions, which would be heard through the Administrative Appeals Unit, not this informal dispute resolution process.
So for the informal dispute resolution, is that something that the owner has to be present for?
They can submit it either in writing, or we've done phone calls. Now with Zoom. Everyone's gotten comfortable
Right.
with Zoom. We've done some meetings that way. For some historical purposes, we've generally do about 10 informal dispute resolutions processes a year. We have approximately 740 licensed child care programs in the state, and we tend to do about 10 of those informal disputes a year. Every program gets a visit every year, at least one.
And then my final question will be, so has your department and perhaps proprietors of childcare facilities tried to make changes without having to form a commission? I mean, I know that there's been a lot of complaints, and I would think that that would incentivize someone to, incentivize the department to perhaps look into this without us having to go this far, to where yourself and some proprietors got together and said, hey, this isn't working, let's see how we can do this. Has that been
So-
something that the department's thought about?
So one of the things that we're doing is we're looking at what our adult licensed facilities do. They have separate processes. They have different processes that they do, and we have been looking at that. We've also reached out to other states to see what their processes entails and how they do it there. So we have started looking at it, but honestly, I mean, we're not opposed to this commission coming together, so we
Okay.
can get even more ideas from other areas that we might not be thinking of.
Perfect. Are there any further questions? Representative Long.
Thank you, Madam Chair. Thank you, Ms. Clement. The informal dispute resolutions, of the 700 programs, how many, an average per year, would there be a finding of a violation?
So the almost all programs, honestly, there's findings. We have what we call critical rules, which require a corrective action plan, and then we have non-critical rules, which we note as something that needs to be corrected, but a corrective action plan isn't required. Almost all programs probably receive either a critical or a non-critical rule because of the number of rules that we have. So it's the fact that I said that we have 740 something programs and that we have about 10 disputes a year, I would say the vast majority of those programs have received either a critical or a non-critical finding.
So, follow up if I may? So the critical and non-critical, at which point, I remember the issue was that some of these daycare centers had to stop until this was, adjudicated. So I'm trying to think with respect to critical and non-critical, at what point do you may suspend the license or?
So if, I mean, suspension or revocations are even more rare than the informal dispute resolution process. We do, I mean, I think last year we didn't do any. The year before, I believe we had one that was revoked. Prior to that, we have, maybe 2 or 3 a year. It's very rare that we get to that point. And that process goes to the administrative appeals unit, so it is not part of the informal dispute resolution process. So anytime a program's license is in jeopardy or there's action taken on a license, that goes through the administrative appeals unit, not this informal dispute resolution process.
Okay, great.
This is just for the findings at visits that are requiring corrective action plans.
Okay, thank you.
You're welcome.
And so I have one more question now.
Sure.
So, I mean, would you agree that maybe last year and the year before are not the years to actually
Oh, yeah, absolutely.
count how many times this has happened? I mean, if we could get some data from before that, I think it would be
Yes,
great.
yeah, I believe
but
I
I just
provided it in
don't
previous
think-
testimony, so I can certainly bring that to this
Okay.
committee as well.
Great. All right, thank you. Are there any further questions? Seeing none, thank you so much.
Okay,
Have
thank
a
you
great
so
day.
much.
Okay, so I have no more pink cards, so I'm going to close the public hearing on HB 1364, and our next hearing will begin at 9:30. Good morning again, everyone. I'm going to open the public hearing on HB 1520 and call on Representative Cody Belanger, who's asked for 3 minutes.
Thank you, Madam Chair, members of the committee. Excuse me one second. Feels like it's right in front of my face. Thank you for hearing my testimony today. I greatly appreciate it. For the record, my name is Representative Cody Belanger, and I represent the center of the universe, and that is Epping, New Hampshire.
Some may disagree.
You asked my constituents that, and I think we might have a brawl. This bill seeks to provide transparency back into our guardian ad litems. The story that I'm about to tell you today, you probably heard before, or I've talked to you about it personally, but many of you know that I have adopted my nephew, and he is now my son. The process in which requires that we needed a guardian ad litem. The guardian ad litem was appointed, and I was not aware of such a cost, which was $1,700. On numerous accounts, I asked for a bill, and she never responded. So I looked at the statute, and I noticed that she's not required to provide one. And I said, well, why the heck is this the case? So this is why this bill is before this committee. It is a simple tweak, so simple, it's not even a full half a page. All it does is seek to require the guardian ad litem, which shall provide an itemized bill to the paying party, and all parties shall have the right to request the itemized bill for review. That's it. Short, sweet, simple, to the point. For that, I'd be happy to take any questions.
Thank you. Thank you for your testimony, and thank you for this bill. I just wanted to ask you, can you think of any other service that you get that does not give you an itemized bill for the services rendered?
Nope, I don't think so.
Thank you. Are there any questions for Representative Belanger? Seeing none. Thank you so much.
Thank you.
Okay, well, I have no more pink cards. That's the quickest hearing we've ever had. So I'll close the hearing on HB 1520. Okay, good morning, everyone. I'm going to open the public hearing on HB 1518 and recognize Representative Cody Belanger.
Thank you, Madam Chair, members of the committee. Again, my name is Representative Cody Belanger, and I represent the Center of the Universe. This bill was kind of a thought bubble last session, of last part of the first session, excuse me, when I brought forward my bill for adoptions. And one of the comments that got brought up to me was, is there a home study done in the first portion of guardianships? And the answer is no. And again, going back to my story, my wife and I adopted my nephew. We filed for guardianship, and we had him from August of 2018, and we were his guardians until August of 2021. So to give you that time frame, in that time window, nobody came to visit the house to make sure that he was living in a safe environment. Now, granted, we have a safe environment, of course, but no individual, no DCYF agent, no child care agency came out to do a safety check, if you will. So Thought Bubble was born. There are some things that I need to address with the child care agencies. The DCYF has reached out, as you've seen in the fiscal note. The intention is not for them to do it, as the fiscal note clearly states. They would need to add additional staff. Wasn't really sure, and I have reached out to multiple child care agencies, and they think this is feasible. The other problem that we're running into is the cost. As currently the way that the bill is written, it states that the $125 would be paid for by the guardian to the courts. But what needs to be amended, and I apologize, I don't have an amendment today, but I will be bringing one forward. The cost will go to the child care agency, but the judicial branch will still be allowed to waive, as they currently do in the petition process when you are petitioning to be a guardian. The other concern that was brought up was the term adequate. Who determines that? Currently, the way that the process is done in an adoption case is that you have the child care agency come out, they do a determination to see if you have a safe home, and then it is sent. The report is then sent to the court, and then the court reads it, and then they decide. It would essentially be the same scenario, if you will, and that will be the intention. So what we want to do is provide the same process. The other thing, and I'm not entirely sure of, as I have not heard back from the child care agencies, excuse me, if 30 days is adequate enough for them to get out there, provided that a guardianship has been placed. There will be an amendment brought forward, hopefully by the end of this week. I asked for the request, but they did not get it back to me in time. With that, I'm happy to take any questions. I know it's a little confusing, and I apologize, but you will have the amendment by the end of the week.
Okay, thank you very much. So I have a couple of questions. So currently what is the cost for the home visit?
If I might clarify, Madam Chair, you mean for an adoption?
If that's what this bill refers to, then yes.
So currently there is no visitation during the guardianship process, so there is no cost. But the cost of
The
a home...
cost of the visit shall be no more than $125 paid for by the guardian. The court may issue a waiver for this expense.
Correct.
So currently there's no cost for that?
Correct, because there's no process that's currently being done.
Okay. And then my next question is, when you refer to child care agencies, what are you referring to?
We're referring to, as it states, a child care agency approved and licensed by the Department of Health and Human Services, such as Beckett Family of Services, Waypoint. I'm sorry, those are the only two ones that I know off the top of my head.
Okay, thank you. Further question, Representative Long?
Thank you, Madam Chair. Thank you, Representative. So just to clarify on the first page 22, the $125 will be paid for by the child care agency. Is that what you're looking to amend that by?
Thank you for the question, Representative Long. And no, so the intention will be that the guardians will still pay that, but they will
Okay.
pay it directly to the agency rather than the way that it's currently written. It says paid to the judicial branch, and that was not the intent of the bill.
Okay, so the guardian will pay directly to the child care agency.
Yes, sir.
Okay, and the $125, how was that
It's just a placeholder.
placeholder? Yeah, 'cause, I mean, I know Waypoint is $1,000, their home studies.
Their home study is $1,100. That's
$1,100.
that's a bit more of an extensive process. I mean, you're going through background checks, and the intent of this is just to ensure that the house is safe. Knives aren't out. You got a pool that's uncovered that the kid could fall through. Because if I'm being completely transparent, when I first got a kid, these were things that I didn't even think of. And it's just to make sure that the house is safe. There's no book about being a parent. I mean, there are, but
Right.
it's not easy.
One more follow-up?
Follow-up.
So, and with respect to receive a home visit, are there different kinds of home visits? Should this be defined as to what you're looking for? Whether, it's a high end or a low end, or, a home visit, it's not detailed as to what that would be.
So, thank you again for the question. So one of the things that was suggested was that we take a look at the adoption statute and see what is said. I definitely don't agree that we need an entire adoption statute essentially applied, but I do agree that the home study should kind of be outlined as to what the expectations are. Again, that's going to be the cost analysis and what that cost is going to be for Waypoint or other services that would be doing this.
Okay, and one more if I may.
Sure.
So if this bill were to pass, if a grandparent received guardianship, this would require the grandparent to pay for a home study, correct?
Correct. But again, they'd be able to file for that waiver when they're filing for guardianship at the judicial branch.
Okay, all right, thank you.
Okay, Representative Smith was next.
Thank you, Madam Chair. Thank you, Representative Belanger. As someone who has gone through the adoption process 3 times, that blows my mind that there's nothing that you can just take a kid and be like, okay, this is my kid, and no state services have to come in. We had to pay for everything with an adoption, but they came in multiple times in 6 months. They came in 6 times in 6 months, and we had the privilege of paying for that each time they came in. And they talked to my other kids. They looked all around my house. That's mind-boggling that there is no, first 60 days, 90 days even.
Do you have a
that they're-
question?
Oh, I'm sorry. So it's not set up like the adoption process, and that's what you're looking for, that it will start. It will start to kind of mimic the adoption process. Is that what you're talking about? That it would mimic a home study, but not as big.
Thank you for the question. Yes, I mean, essentially, when we filed for guardianship, we saw nobody. In, again, 18 to 2021, no one came to visit except for that adoption process, which ended up taking place between September and December of 2021. 2020, and I apologize. Nobody is coming to visit these homes during a guardianship process. There is no requirement to do so. So this is just seeking to, and again, this was brought up during the first part of the session when I brought forward an adoption bill. Many members of this committee were like, wait a minute, we're trying to fix this adoption piece and make it a little easier, but there's nothing being done on the front end. And I was like, oh wow, you're right. I completely forgot about that part. Let's go ahead and fix that this session.
Okay.
So that's exactly what this is trying to do. Rome wasn't built in a day. It's going to take a little bit of a process to kind of go through some of these bills, through some of these RSAs and fix them to kind of mimic. But this is an important piece. I mean, you can't. Someone who has gotten guardianship twice and have adopted once, it blows my mind that there's no process for someone to come and visit the home. And that's what this bill seeks to do.
Thank you.
Oh my gosh, I totally drew a blank. Representative Grossman, I'm sorry.
Thank you, Madam Chair. And thank you for bringing this forward, Representative Belanger. Can you describe your amendment that you're planning on just a little bit more? And will it include the definition of home study?
If I may, I would really not want to discuss the amendment until we have it in front of us. You know what I mean? I think if you want to ask the question, will it include the definition of home study would be, a good question. But I really feel it's kind of putting the horse before the cart before the horse to talking about an amendment that's not in front of us.
Thank you. Can I ask, will it include the home study definition? Your planned amendment that we don't have.
Yeah, so it wasn't going to, but as to Representative Long's point, it should, and to yours as well. And thank you for the question. Sorry, I'm trying to jump the gun here, talking about putting the cart before the horse. And so when I get it back, I will ask for clarification, and that'll be one of the first things that I do this evening instead of going and taking care of my sleep.
Representative Altschuler.
Thank you, Madam Chair, and thank you for taking my question. Representative Belanger, on line 24, part C, you have in the event that the home is neither, and the three words I'm focusing on here are safe or adequate. And in RSA 436, under definitions, neither safe nor adequate are defined. Would you be open to putting the definitions in your amendment?
Thank you for the question, Representative Altschuler. So to answer your question, no, but not because we don't want to. It's more so the fact that in the 469, it's not stated. So we want it to mimic as I'm a only sponsor on this bill, I want it to mimic the adoption statute and allow, adding in the either safe or adequate really kind of leaves that up to personal opinion. I want to 86 that.
Follow up?
Thank you, Madam Chair. Thank you for taking my second question. With regards to the fiscal note, it's going to be a significant amount of money, much more than $125 would cover, because it looks like the Department of Youth and Family Services will be required to do a home visit or sub out a home visit, write a report on that home visit, submit it to the court, and then it says that whoever performed the home visit is also required to appear in court. So, based on how many foster placements, because this is what this deals with specifically, right? Is the foster placements, guardianship placements. My bad, sorry. guardianship placements, we do have a number on how many guardianship placements we've had over the past couple of years to get kind of an average. Have you had any more information come to you since this was printed from those agencies to give us an idea of what we would be needing to supplement their budgets with to make this happen?
Thank you for the question, Representative. So, as I stated earlier, we're gonna. I do agree that it should be. Currently, the adoption process is that in a child care agency such as Waypoint or Beckett Family Services does an adoption home study, and the intention would be for them to also do this piece of it. I believe the intention will be within 90 days, and we don't have a cost yet, but we will. And if I may preface that as well, I don't think in the adoption statute of the home study process that there is a cost limitation. So we can always remove this cost analysis completely, and it doesn't limit the agency, and hope that they don't overcharge for a simple home study, which is going to be far less than what would be required of the adoption process. And I just want to add too, if I may, Madam Chair, when you file for guardianship, and the reason why the process for a guardianship visit is going to be different than the adoption visit, is when you file for guardianship, you must also give you must sign a document for a background check, and I do believe, it's been a while, a child abuse and neglect document as well. So when you file the guardianship paperwork, that's already filled out, and that's the only background check, if you will, and I'm putting it in air quotes, that's the current process now. So you wouldn't need to add that to this part of the home study. Wouldn't be necessary because it's already being done.
Are you all set, Representative Altschuler? Yes. Okay. Are there any further questions? All right, seeing none, thank you so much.
Thank you, Madam Chair.
Okay, and that was my one and only pink card, so I'll be closing the public hearing on HB 1518, and we'll be back at 10:30. Oh, that wasn't, oh, you scared me. I'm like, oh, I missed one? Okay, everybody. We are now ready to open the public hearing on HB 1303, and I will recognize Representative DeSimone.
Thank you, Madam Chair and committee members. For the record, I'm Deborah DeSimone. I represent Rock 14, covering Atkinson and Plaistow, two of the most southern towns in the state. Thank you for listening to me today. HB 1303 is merely housekeeping. The current RSA 458, if you go to Roman numeral 7, it states when either party is an habitual drunkard and has been such for 2 years together. That language is very archaic, obviously. And in today's times, we have other unfortunate issues. So that's why this bill changes it to state when either party habitually abuses alcohol or drugs and has been doing so for 2 or more years together. That's all it is it's changing the verbiage to bring it up to date.
Okay, are there any questions? All right, seeing none, thank you so much.
Thank you.
And I'm an absolute failure on scheduling today. Oh, wait, there's a question. Representative Altshuler.
Sure.
Yes, thank you. I'm sorry, I was calling up the RSA to compare it. I'm sorry, I was a little slow on that one. Thank you very much for taking my question. Where you have changed, where either party habitually abuses alcohol or drugs and has been doing so for 2 or more years, does together synonymously go with consecutively? And
Yes.
and if someone has engaged in some sort of a treatment program, but then subsequently fallen out of that program and relapsed, does it start the clock over? I'm like,
Yes.
so
It would be, that's why we specifically kept the words 2 years together. Simply because if you look at rehab and what happens with people who try rehab many times, it takes a few efforts to get there. So if a person is habitually abusing for 2 years together, and then they go to rehab, and they're in rehab for X amount of time and come out, they have not been habitually offending or imbibing for whatever time they were in rehab. So the clock is going to start over. It's unfair to do it in any other way, as far as I'm concerned.
Follow up?
follow up. And I'm assuming, but I don't know where it falls in this section, that the starting of that clock, so that there is an accurate, like, it's been this long, is done by the courts. So something would have to be submitted, right? Saying like,
Yes.
I have engaged in this program, so on and so forth.
Yes.
And does that need to be stated, or is it just implied?
I believe it would be implied. It would go to the judge's authority.
Okay, thank you very much.
Thank you.
Okay, are there any further questions? All right, seeing none. Thank you so much.
Thank you.
And folks, that's a wrap on HB 1303. Okay, members, we're gonna, give me 1 second and I'll get Representative Yokela back here and we're gonna go and exec 3 bills. Okay? We're going to do 1520, 1364, and 1303. I'm going to open the exec session on House Bill 1520 relative to the procedures for guardian ad litem. Representative Belanger, do you have a motion?
I do, Madam Chair. I make a motion OTP.
Seconded by Representative DeSimone. Is there any discussion? 1520 relative to procedures for guardian ad litem. We heard it this morning.
You want me to go get you one up there?
There's copies on the table. Hi.
Hi. So my concern with this bill is that it doesn't really seem to. I'm not sure that it's going to actually help. The person, it seems to me, could just provide a bill that says services rendered or services regarding, guardian ad litem decision making process. And so how specific they need to be about, what they're doing doesn't, I am not sure that this is actually going to result in them saying, okay, I showed up at this place for 15 minutes and we're going to charge you $200 for that.
Well,
kind of
I
thing.
think that is what the word itemized
Right, but
refers to. Am I correct? That's how you get an itemized bill from a GAL, is they have to put that in there. And I mean, if we pass this and then find out it's being done like that, then I think we can go. But I don't think we need to do that. I think itemized really speaks clearly to it.
But we also didn't have any GALs testify as to what a bill like this would look like.
Well, that's their fault. They had every opportunity to come and testify, you know what I mean? Representative Belanger wants to say something.
If I may, Madam Chair. This isn't being done at all. And that's what this seeks to do. Obviously I'm privy to it and I have personal experience with it, but when I send, for my business, when I send a bill, I send it itemized. It shows the flat rate, it shows the gratuity that a customer is paying. If it's on the card, it shows the fuel surcharge, which is 5%, and then it shows what the total bill is at the end of the trip. That's an itemized bill. And if I don't send that and I just send the customer the total charge, 9 out of 10 times they just go, well, what was I charged for? And they want a breakdown.
And I think
that brings fairness to this.
And I think it would also, with it saying itemized, you could bring to the judge's attention, is this what they consider itemized? Right? I mean, I really think that itemized speaks to itself and is going to get the clarity we're looking for. Representative DeSimone.
Thank you, Madam Chair. I think that the fact that there's not one guardian ad litem in this room, and they haven't sent any emails either, speaks to the fact that this is no concern of theirs.
I agree.
So, as far as I'm concerned, the concern is the constituent who has to pay these bills, and itemized. I don't think the language can get any stronger. Thank you.
Anything else? Representative Long.
Thank you, Madam Chair. So right now, the guardian ad litem says 1,700, right? Because that's the bill you get, somebody would get for a guardian. Itemized means I traveled this far to here for gas. I visited these participants for an hour, for a half hour, or just visited. At least it's broken down as to what the guardian ad litem did. As paying for that, I at least want to know that you put in the effort, that you visited the people that you ought to be visiting. So, in my opinion, this itemized bill is more than what they're getting now.
No doubt, it's more than what they're getting now.
Okay.
Is it correct that really the guardian ad litem is there to serve the court, to gather information for the court, and so if their report to the court was not adequate, then it would be the courts that would say, hey, you're not really doing your job here, and the person paying for it really is not the person that is really judging their work product, if that.
Well, I think this could offer up the questions to the judge. Hey, this didn't happen, or what is this? But people have a right to know what they're paying for. I think that's
Right.
basically what it is. You're getting a service, and you have the right to get an itemized bill. I can't think of one instance that you don't get an itemized bill from someone for a services rendered. And why this should be any different is beyond me. So that's where I'm at. Okay? Is there any further discussion? All right, seeing none, I'll ask the clerk to call the roll.
Madam Chair Rice,
Yes.
Representative DeSimone,
Yes.
Representative Yokella,
Yes.
Representative Nelson,
Yes.
Representative Belanger,
Yes.
Representative Cross, Representative Litchfield, Representative Smith,
Yes.
Representative Long,
Yes.
Representative Aliseo, Representative Grossman,
Yes.
Representative Lebec,
Yes.
Representative Wazir, Representative Alchala,
Yes.
and I, the clerk, Representative Petrino, yes.
So, HB 1520 will go to the floor with an on to pass recommendation unanimously.
12 to nothing with 3 no
Consent?
votes.
Any objection to consent? Seeing none, this will go on consent calendar. Representative Belanger, please have the committee report to me before you leave today. Okay, up next, we'll do HB 1364. Do I have a motion? Okay, I'll move ITL.
Second?
And Representative DeSimone seconds it. And I'll just say that I spoke with the sponsor, and she agrees that we're concerned that the time frame of this is not actually enough time, and we don't want to shortchange this study, which is really needed. So she agreed with me that we could bring it back next year, and I actually agreed to co-sponsor. Any further discussion? Seeing none, I'll have the clerk call the roll.
Representative DeSimone.
Yes.
Representative Yokella.
Yes.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Cross. Representative Litchfield. Representative Smith.
Yes.
Representative Long.
Yes.
Representative Alicea. Representative Grossman.
Yes.
Representative Levesque. Yes. Representative Wazir. Yes. Representative Altshuler.
Yes.
The clerk, Representative Petrino, is yes. And Madam Chair,
Yes. So 12 to nothing?
12 to nothing.
All right, 12 to
Consent.
0. The bill will be will go to the House for a recommendation of ITL. Is anyone objecting to consent? Okay, this will go on the consent calendar. Representative Rice, please have your committee report to me before we end today. All right, and then up next is House Bill 1303. Representative DeSimone, do you have a motion?
I do, Madam Chair. I move OTP.
Is there a seconded by Representative Belanger? Is there any discussion?
Madam Chair.
Representative Yokella, do you have discussion?
Yeah, so we are not just changing drunkard to alcohol use or abuses alcohol. We're also adding drugs. And I think that gets us more down this line of like trying to have fault and no fault and
Right.
all of that, where I think we probably should just be moving more towards just no fault and not trying to prove it in a court of law. So I'm not sure that this is moving us in the right direction. If we were to say that this is just a house cleaning bill, then I think that we should have removed the or drugs part, because then we wouldn't be expanding the list.
Okay, Representative DeSimone?
Thank you, Madam Chair. Until we get to the no fault, I think we need to include this because drug abuse is a serious issue, and that's why it's being added. When we get to the no fault, I'm happy to co-sponsor or sponsor a bill that would remove this verbiage.
Any further discussion? All right, seeing none, I'll have the clerk call the roll.
Representative DeSimone.
Yes.
Representative Yokella.
No.
Representative Nelson.
Yes.
Representative Belanger.
Yes.
Representative Cross. Representative Litchfield. Representative Smith.
Yes.
Representative Long.
Yes.
Representative Alicea. Representative Grossman.
Yes.
Representative Levesque. Representative Wazir.
Yes.
Representative Altshuler.
Yes.
Representative Petrino, yes. And Madam Chair Rice?
Yes. Do you
Consent.
have any objection to consent calendar? Okay, so this will go on the consent calendar, and Representative DeSimone will have the committee report to me before,
I will.
we leave today. Okay, great. Thanks, guys. Okay, everyone, welcome back. Okay, and I'm going to open the public hearing on HB 1103, and I will recognize Representative Spillane.
Thank you, Madam Chair, members of the committee. I agreed to introduce this bill and submit it this year, although it was submitted last term by Representative Reed. It kind of got lost in the COVID stuff, I think. But I have personal experience with what we're dealing with here, and it's very important to me that we right a situation that I see as wrong. So what this bill is seeking to do is to ensure that the division of assets remains a process of being fair and making both parties whole, and not being used as an act of revenge or basically malice. I was unaware until I went through my divorce 3 to 4 years ago that a judge in the family court can just order you to sell something that you own, even if it's been in your family for generations, if they want to equalize assets. In my specific instance, I had a truck that I owned, she had a car that she owned, and then I had my motorcycle. And the judge ordered that in order to equalize the value between the truck and her car, which was a known value, we had estimates done on the truck, estimates done on the car. Blue Book values were known, so we had the known gap between them was $3,500. And he said, you must sell the motorcycle and then give the first $3,500 to her. And I said, Your Honor, I have $3,500. Can't I just give her $3,500? We appealed his decision. He denied the appeal to his decision and said, no, you must sell the motorcycle and give me proof that you've sold the motorcycle. So I come to you today with this bill that says that if you've got the money to make it equal and you want to do that instead of selling a personal item, the judge can't order you to dispose of that personal item. For me, it was just a motorcycle, and it wasn't really even a fantastic motorcycle. It was just my motorcycle. It wasn't an expensive Harley. It was just a Honda. But the value between the vehicles was known. We knew how much money I needed to get, and if I have that money and I can just make it whole and make the division equal without having to sell it, I should be allowed to. That could have just as well been an armoire that had been in my family's family for generations and generations, and it could have been ordered to be sold, losing a family heirloom. And that's just not right. That's not what the whole process of division of assets is supposed to be. And I think it causes more animosity between the couples in a situation that's already rough. So I would rather see that we tell the judges, you can't do that. If they've got the money and they want to just equalize the value, let them pay. And that's all I've got.
Okay. Are there any questions for Representative Spillane? Representative Belanger.
So, thank you for being here today and bringing this bill. I'm not familiar with divorces, and I hope that I never am, but correct me if I'm wrong, but so I have a $5,000 asset, and it needs to be split into two. Is that correct?
That's one instance where they split them. Yep.
And this is just seeking to kind of fix that so it's more of like a fair value, right? Like,
Yeah, if the value is known and you're looking to divide it, then you should be allowed to use cash to make that work, not have to liquidate the asset to make it work.
thank you.
Any further questions? Representative Long.
Thank you, Madam Chair. Thank you, Representative. So, when we know the value, I'm thinking of when we don't know the value with respect to, it says fairly compensate the other party for their interest. Now, what if it's a brochure, a brooch or whatever that my grandmother was my great-great-grandmother's. We don't know the value.
Thank you for the question. There's actually two values to that. One that's not addressed by the court, which is your sentimental value, correct? Then there's a monetary value that can be appraised by any jeweler. And the judge has arrived at his determination that there's a value to it. And like in my case, he had assigned a value between the two vehicles after the Blue Book values of the trucks, and he knew how much money had to be made up. On the case of the brooch, if it is appraised at a certain value, and part of the divorce proceedings is we had to go through our assets and assign values to them. And then the other party could dispute what the value was, or they could accept those values. And that's all part of the whole discovery process in the beginning leading up to things. When those get divided, that's when the judge says, well, I understand this is worth X amount of money. And he can turn around and say, rather than you keep it and give her money, I'm going to make you sell it. And that shouldn't be allowed.
Okay, thank you.
Representative Smith was next.
Thank you, Madam Chair. Thanks for taking my question. So is it up to is it with the judge's discretion of whether or not you can sell it, or is it you have to sell it?
The judge makes the determination. In my instance, his order was that I must sell it, and when we appealed the order, he denied it out of hand and said, no, you must sell it.
Okay, but it would be up to the judge whether or not.
It is up to the judge
Okay,
right now.
okay.
And what we're seeking to do is sort of tie his hands just a little bit and say, if the money's available. Now, I have no problem with liquidating an asset where the person can't come up with the money, such as a home. You know, if you don't have the money to pay out and equalize it with cash, selling it and then dividing the proceeds is the way they usually go. That shouldn't be used in a situation that's going to cause more strife between the parties.
Okay, thank you for taking my question.
Representative Altschuler?
Thank you, Madam Chair, and thank you, Representative Spillane, for taking my question. In the statute right now, I see that your proposal is to add a section 4.
Yes.
Right.
Well, it
Actually,
says
I'm sorry,
five.
add a section
Five.
5.
5, yep.
And currently, under section 4, it says the court shall specify written reasons for the division of property which it orders. So, did the court not specify the reasons for?
The reason given by the
Your-
court was that the difference in the two vehicles, primary vehicles, was $3,500. And so they ordered the sale of the motorcycle, which was considered a secondary vehicle, with the first $3,500 I got from selling it to go to her. So in that instance, their written reason was just, the values aren't equal, so you must sell it. They did not give a written reason as to why selling was imperative or why he refused the appeal to just give cash. No written explanation was given, and I don't know.
Representative DeSimone?
Thank you, Madam Chair, and thank you for taking my question. I appreciate it. I'm not seeing anywhere in the RSA that it says that you cannot create a bill of sale and purchase the item yourself.
There's a lot of ways of getting around things. I ended up selling my motorcycle to a friend, and a year later I bought it back again. But why should I have to go through that if I had $3,500 right there? And it ended up just causing a lot more animosity during the divorce process because now it was looking like it was a revenge thing.
Thank you.
Any further questions? All right, seeing none, thank you so much.
Thank you.
And up next is Representative Ellen Reed, and she does have written testimony.
Thank you, Madam Chair, and thank you, honorable members, for welcoming me to your committee. This bill was originally my bill. I put it in last term, 2020, the year. It was out of this committee, ought to pass on consent, headed over to the Senate, in the Senate, I believe, and was one of the casualties of the mass tabling event. As my testimony says, this was originally brought to me by a resident of my county who went through a divorce similar to what you just heard from Representative Spillane.
The judge ordered the sale of a sentimental vehicle. The person offered to give the money directly, the cash directly, and the judge denied that. So, not knowing a lot about child and family law, I wanted to make sure that before I put a bill in on behalf of this person, that I was doing my due diligence and making sure I didn't mess anything up. So I contacted UNH Law School and I asked them, is there any reason a divorce judge should be allowed to force the sale of something when the other party has the cash to compensate the other party? Not a single lawyer at UNH Law School could tell me that there would be such a reason, nor that would there be any reason not to have this in statute. The Domestic Violence Advocacy Project and NH Legal Assistance both reviewed this bill. This is the same exact language that I used last term. And both organizations found no reason to oppose this bill. So with that, I felt safe enough to proceed forward with the language. And I presume I'm, kind of preaching to the choir here when I say that divorce judges are instructed in law to determine the equitable division of marital property. So that's what their instructions are. And if someone is able to fairly compensate that cash amount that the judge has ordered, and yet the judge says, no, you have to literally get rid of your property that you have a sentimental attachment to, that doesn't benefit the other party at all. It's just punitive. And in that case, I feel that the judges are overstepping their directions in kind of punishing someone just by making them give up something that they are sentimentally attached to. So I'm happy to answer questions. I have several references that I've included on because I did do my research last time.
Okay, are there any questions for Representative Reed? Okay, seeing none, thank you so much.
Thank you so much.
Okay, and that will conclude the public hearing on House Bill 1103. We'll be back at 11:30.
Yeah, the only thing about execing is we weren't going to exec, so some people may be looking online. I get it that if we could exec and we all agree, let's get it off our table. However, there's members that are streaming in for whatever reason why they couldn't get down here, where they're not going to be on the record as voting. But I mean, if we could exec the bill, let's exec it.
Let's just get a little less off our Okay, I'm going to open the exec session on House Bill 1103. Representative Levesque, do you have a motion? Is there a second? Seconded by Representative Belanger. Is there any discussion? All right, seeing none, I'll ask the clerk to call the roll.
Representative DeSimone,
Yes.
Representative Yocella,
Yes.
Representative Nelson,
Yes.
Representative Belanger,
Yes.
Representative Cross, Representative Litchfield, Representative Smith. Yes. Representative Long. Yes. Representative Alisea. Representative Grossman.
Yes.
Representative Levesque. Yes. Representative Wazir.
Yes.
Representative Alsala.
Yes.
Representative Petrino, that's me, yes, and Madam Chair Rice.
Yes.
Okay, that is unanimous.
So the motion is adopted unanimously. Any objection to consent? Seeing none, this will be placed on the consent calendar. Okay, everyone, welcome back. I'm going to open the public hearing on House Bill 1118 and recognize Representative Barbara Griffin.
Thank you, Madam Chair. Thank you, honorable members. My name is Barbara Griffin, and I am a representative from Goffstown. I propose and ask for your support for HB 1118. This bill proposes to add a fact to be considered by the court in a determination of parenting responsibilities where a parent has died or a guardian who has held the position for 2 or more years has died. And the fact that I'm asking to be considered is the contact that the child has had with the surviving parent and the wishes of the guardian in estate planning documents. Again, the period to be considered after 2 years. I bring this legislation because of my years of practice as an attorney and a guardian ad litem, and particularly in the past 2 years, the need to consider this fact has become apparent. Before I get into that, I've been practicing since 1987, have held a license in Massachusetts for many years, currently hold a license in New Hampshire. I have a master's in social work from Boston University. I've conducted criminal and civil jury trials. I've appeared before the Supreme Court. But over the last decade plus, I have focused my practice on family law matters. In that role as attorney and guardian ad litem, I have seen the number of termination cases rise, and they have risen specifically over the past couple of years due to COVID. Children are being exposed to the issues of COVID outside of the issue of exposure to COVID. And from a child's perspective, that is what had become a very frequent topic of discussion of death. And children like stability, and I was finding a lot of clients, people bringing forward petitions who, when asked, why are you bringing this forward, the response was that the child in their care wanted to know what would happen if anything happened to the person they recognized as their caretaker, and that caretaker realized that they had no ability to have any say in what would occur should they die. So children themselves may or may not be subject to parenting orders, and when they are, they may have contact only with one parent, not due to any court orders, but actual practice. And I've run into that in a number of cases, and have currently and have had terminations where the other parent has simply been absent. So the question in the termination in those cases is clearly just one of best interests, and are the facts there to allow the court to enter the termination. Children can also be with guardians. Sometimes they are family members, sometimes they are not, and have little or no contact with the parents who may or may not still be in the area. And these arrangements do go on and on for years. I have been in the home of grandparents who have served as guardians. Maybe a child has substance abuse issue. They consistently voice the hope that the child will someday become competent to parent and conquer their drug addiction. And I, frankly, in all of the cases I've had any follow-up, that has not happened, and the grandparents or other guardians have gone on to become the lifelong guardians of that child. So it does happen for many reasons. And as I stated earlier, with COVID, there's a generation of children who have become directly confronted with the possibility of death in either themselves or their caretaker, because it was flat out part of the whole school thing that went over was that everybody was so sick and might die and you couldn't go out. So it did become a very real fear for children who are often in situations that aren't providing the greatest stability to begin with. So it really did have an impact. So whether or not that exposure to the issue of death due to COVID was an appropriate thing to be exposing children is really a question for another day. The reality is it happened. And they were asking their caretakers, what's going to happen if you die? I had guardians say they were on a car ride. They were in the car. I mean, as a parent, you know, I'm sure many of you that some of the darndest things get said from the back seat of an automobile, right? And that comes up. So at that point, the reality that a biological parent who may or may not be able to parent and who may or may not have had any interest becomes essentially the legal winner in what may occur if there's a death in what is the caretaking parent or a guardian. And again, I come back to the fact that I, along with other guardians, have had more terminations in the last 2 to 3 years than we have during our entire practice years. And the compelling reason has been that a caretaking arrangement has been in place, and the reality of what a death would do to it has become apparent. Now, whether or not parents are involved or not involved, or the bill goes forward or not, whether it's good in a particular circumstance is not what this bill seeks to do. What this bill tries to do is to allow the court to consider what other options might be appropriately available in the consideration of entering parenting orders. While the best interest standard may include a lot, we know that persons disagree on what it should include and what weight it should be given. What I am asking you to do is to ask the court to require a consideration of the wishes of a deceased guardian or the actual contact a parent may have had. The 2 years selected was not entirely arbitrary. I do a lot of DCYF cases, and in those cases, of course, the presumption is that a parent has a year in order to correct the conditions that led to the finding of abuse or neglect, at which point the court is required by federal law to issue permanent orders. The reality is those abuse and neglect cases, by virtue of the calendaring, pretty much all go more than a year, and I've had cases where the year, which starts at the finding, not the initial hearing, has gone on for almost another year by virtue of trying to give that parent an opportunity to get the skills that would allow them to become a parent. So in abuse and neglect, the legal standard is a year. 2 years is really sort of where you get to see that a parent is going to be able to go down the path of rehabilitation and assume the care or not. And in a guardian situation, as I said, many of them start off with the view that they will be temporary, right? The child who's the parent is going to be able to remedy the situation or will come back, right? They've moved away, so we've assumed the care of maybe someone who's not a family member in order to continue that relationship. But when you get to be 2 years, you've established a new reality for children in regards to their stability and what should happen. So that's where the 2 years came from. And I just want to remind everybody that as an attorney, in any case, is constrained by the facts, right? I mean, the facts are what a court has to consider. And the clients in their lives are the facts that go before the court. And the court is the one who has the ability to consider the facts, but they're constrained by the law. So as an attorney, I'm constrained as what I can do with a client because the client has brought me the facts, and that's all I have to work with. And the court needs to be given the opportunity to take those facts and apply the law. And I'm in an effort to give the court the opportunity to consider what has become, in a 2-year situation, the normal. I've proposed this bill to allow the court to take into consideration either the intent of guardians when they have done estate planning documents or what the actual contact has been with the parent. And I'm not saying that's going to prohibit a parent from coming in, but I would like the court to have to consider it. It will give them the ability to do it as compared to someone arguing it should be irrelevant in light of other standards. And with that, I thank you for your time, and I'm happy to take questions.
Are there any questions? Representative Belanger.
Thank you, Madam Chair, and thank you, Representative Griffin, for being here today and providing your testimony and presenting this bill. So, I'm going to preface this, Madam Chair, so before you ask me where my question, I'm going to get there, I promise.
Okay.
So I have adopted someone, and I'm a current guardian of another child. If I die, and my documents state that my guardianship rights go to my wife, even though my wife is not currently the guardian for this second child, and I have proven beyond a reasonable doubt that my relative is not able to care for the child in question, would this bill allow the parent to be considered for my guardianship?
I guess I need to back up a little bit. Reasonable doubt would not be the standard used in these proceedings. As to an adopted child, you are the legal custodian, so your estate wishes would control regardless, and your wife, or if that other person has not adopted. As an attorney, when you walked into my office, I'd say, why not? But that would
I'm
be.
sorry, I just want to, the adoption was just to preface. I'm referring to the second case where I'm a guardian.
No, I know, but
Okay,
but
all right.
you made a certain assumption that we were going to possibly globally treat them the same, and I'm simply pointing out that you've already got a circumstance where even the adopted child would not be treated. There would be some different standards going on. Your estate planning documents under current law would have no legal effect on a guardian child. It might be considered, but there's no requirement for it. As your guardianship terminates at your death or the death of the child, and guardianships are always temporary. You can get a final guardianship order at a final hearing, but the guardianship order itself is temporary and always subject to modification by the parent, I will presume, given the circumstances of most guardianship cases, to reopen it as to either parenting time or a termination. The only difference is the standard that is used in considering whether a guardianship is terminated will be different depending on whether the guardianship entered as a result of an agreement of the parent. By agreement, a lot of time parents agree, we can't do it, we're going to let this person be guardian, or whether the parent contested the guardianship at the time the guardianship entered finally. So under this bill, if you had done estate planning documents, it would be considered as to both children if the adopted child did not have another legal parent. And I'm presuming with adoption that there was a termination that allowed the adoption. And I understand we're talking generally. There's no adoption unless a termination has already occurred. So that parent is legally out of the picture upon the adoptive parent dying. They're no longer in the picture whether the adoptive parent is alive or dead. And the issue as to a guardianship, then it reverts back to the parents under the current law.
And this bill in no way stops a parent from still trying to seek
Correct.
to get the child back.
Correct. I can tell you in guardian reports for terminations, I distinguish often in my reports that there is a difference between what a court in a termination proceeding might do and what occurs in a parenting case. And it's a different proceeding.
Any other questions for Representative Griffin? Representative Long?
Thank you, Madam Chair. With respect to child support, is that any consideration, even though they've been paying child support but haven't had any contact with the child or visitation?
Well, we are told in the practice area that child support and parenting are not related. So, just so you know that. The reality is, just for if the committee will indulge me, child support is a consideration in termination. So, if the termination factual criteria that a court must find must have been in place for 6 months in order for a court to find that the facts exist to consider a termination, and then it considers whether it might be in the child's best interest. So factually, if a parent has failed to pay child support for a child for 6 months, that would be grounds for termination. However, technically, child support is not a factor to be considered in parenting decisions. What it does go to is to the ability to provide for a child, but the payment of child support itself would not be a factor.
Can I follow up?
Follow up?
Thank you. And this is both of these are just, they shall consider.
Correct.
It's not a, you must do, you must,
Correct.
yeah, they just shall consider.
Correct.
And my understanding is what the problem is it correct that there may be another parent comes in?
Correct.
That may have issues, and we wait 2 or 3 years to see if they can get over that issue, and that's what this is addressing.
Yes. And I will tell you a lot of times what happens when there's a parent that doesn't have contact sort of on the other side, so to speak. And I'm not saying this to be to negatively accuse anybody of anything. What you find often is that the party that all of a sudden pays the child support or becomes involved is actually the parent of the parent or the grandparent who has had a grandchild that by virtue of their child not being a parent, that they all of a sudden want to get involved. And you often have parents admitting that that's where the money came from, or that's how they got the ride, or that. Yeah. I mean, this is obviously addressing a very unique circumstance where the parents have not been parenting, the legal parents have not been parenting. So keep in mind, we're in a pretty fortunately narrow group of circumstances, but as the focus on family matters is more heightened and as termination matters grow, I think it's important to give the court the ability to consider a number of factors.
Very good, thank you.
Representative Altschuler?
Thank you, Madam Chair, and thank you, Representative Griffin. As a matter of law, could you please clarify why you have chosen the court shall versus the court may? I believe shall is a little more is more emphatic.
Because
right?
yes, and one of the reasons I did that was I wanted it specifically in the order, because the court would then have to enunciate clearly, that is in a written order, as to whether or not it was considered. It would make it clear to parties and litigants that that would be a fact that they might want to prepare for in connection with any trial or consideration of the order. And it would also allow, if indeed there is a guardian ad litem involved in the case, to consider it, knowing that the judge was required to consider it in a final hearing on any of these matters.
Thank you very much for that clarification.
Any further questions? Okay, seeing none, thank you very much.
Thank you.
And that will conclude the public hearing on House Bill 1118. And we will all meet back here at 1:15.
There you go.
My name, everybody.
They fit your whole name on there.
Yeah, it's funny because it's like,
All of ours just have our last name, except for Smith.
I was talking to Tim about you. She was loving it.
Yeah.
Yeah.
All right. Everybody ready? So I'm going to open the hearing on 1305, and I'm going to call Representative Deborah DeSimone to introduce her bill.
Thank you, Representative, and thank you, Committee. Again, I'm Deborah DeSimone. I represent Rockingham 14, Atkinson, and Plasto. You don't get much more south than that. So I'm going to open this bill 1305, referencing modifying the definition of temporary alimony that a court may award in a pending, and the important word there is pending, divorce case. The reason that we brought this forward is because in a pending divorce case, all of the marital assets are not always already made given to the court yet, or made apparent to the court. So in some cases, a respondent may require temporary alimony to get him or her through financially the divorce case. And in some cases, that can be financially detrimental to the person who's paying that temporary alimony. So what we're asking here is the formula limits in RSA 458-19A, unless those formula limits, a party seeking the temporary alimony pleads and a court finds that immediate irreparable economic harm would result if the percentage of the formula were applied. So it's early on in the divorce proceeding, and we don't want to accidentally create irreparable harm to either party. And that's why this is being brought forward. And I thank you. And I'm happy to take questions.
Okay. Representative Altschuler?
Thank you for taking my question. My concern, and so I'm hoping you can address two things, is that in there possibly being a temporary alimony finding, if that's is that the proper word, or ruling, while discovery is still being made. Is that okay? While discovery is still being made, that then it becomes a baseline that may be inappropriate. Is that, was
Is that your
in-
question?
Was that taken into consideration?
Mm-hmm. Is that your question?
That's my first question. Yes, thank you.
Yeah, and it wouldn't become a baseline. It would become specifically temporary until the order would come forward deciding whether there would or would not be alimony, and if there is alimony, what it would be. This is a temporary situation, and that's all it's meant to be.
May I follow up?
Yes, follow up.
Okay, so my follow-up question is a little off from the first question. There's often parties who will take actions to hide their assets or dissolve assets during discovery. So how would this address someone who may be hiding significant assets?
Well, this is not going to address particularly that area. However, what this is saying is that if you use the formula and it creates a legitimate economic, irreparable, harmful situation, then the current formula would be tweaked a little bit. Unfortunately, you're right. People do liquidate and hide assets during divorce proceedings. And this is so early in the divorce proceeding that it's hard to tell whether they are or are not going to do that. So we hope that the court would figure that out. However, there could be a person in the divorce proceeding that deserves and needs the alimony, but we don't want to devastate the other person in doing that. We want both people to have an equitable situation. I hope that answers your question. Excuse me.
Follow up?
All right, last one. So if, when the court is finding that one party will be paying alimony, what would how would, if that party is, as the court finds to be in a position to be paying alimony, what would the immediate irreparable economic harm be? Because it seems the court is already applying the formula that says they can pay. So, like, where's the...
So, if it comes to the court's recognition that it's going to cause irreparable harm, the formula limits would not be used. The court would make its own finding.
Any other questions? No. Representative Long?
Thank you, Mr. Chairman.
You're very welcome.
Woohoo! You have arrived, Representative.
So with my understanding is the court now, sometimes they don't do a temporary alimony. They just, so the higher earner moves out of the house, and I'm going to ask you to pay the mortgage until we come to a conclusion on this. So is this getting rid of that?
No,
Is that-
no, not at all. What this is saying is, in your scenario, Representative,
Yep.
the one particular party moves out of the house and has to pay the mortgage, but the party that's left behind may have been, and still is, a stay-at-home, non-working member of the couple. And that person would require or petition the court to require temporary alimony. And that's when the court would consider the temporary alimony. Later on in the court proceedings, when they divide the marital assets thus and so, that alimony may be part of the court ruling and it may go away. But it's not going to change anything else.
Okay, so follow up for me? Thank you.
Yes.
So, the temporary, what you're saying may not be temporary?
Well, it will be temporary. However long that temporary portion will be, eventually the temporary will go away. Then it will be up to the court to decide whether this person gets alimony after that.
Okay. So I'm wondering if, because if I'm a judge and I'm seeing that a person is able to pay temporary alimony and plus pay for a lawyer to go through the divorce, that after the divorce, this guy's got a little more money on, he's not going to be paying a lawyer anymore. So I thought Representative Altshuler may have asked something containing to that. My concern would be temporary alimony being the basis, the measure basis for permanent alimony.
Well, it may very well be. If the person doesn't have the opportunity to rehabilitate him or herself and be able to become gainfully employed, this person, for whatever reason, may fall under the parameters of becoming an alimony recipient at the end of the divorce.
Okay.
Again, the temporary portion would have no bearing on the ultimate outcome. It could be that this person needs rehabilitative alimony, which is another statute. It could be that this person needs lifelong alimony. That would be up to the court to determine that.
Okay. Very good. Thank you.
Any other questions? I have some. In the statute right now, it says that there's a maximum duration of alimony shall be 50% of the length of the marriage unless the parties agree otherwise or the court finds that justice requires an adjustment to that. And in your bill, you cross out on line 5, you're crossing out that this temporary alimony shall not be counted towards the essentially the 5 years of, or 50% of the time of the regular alimony. However, this temporary alimony may be a different amount than would be required on the under normal alimony. So if this temporary alimony was for, let's say, a year, and it was 50% less than the final judgment of alimony, then the person that got the alimony judgment would be essentially have this temporary alimony would have counted toward their 50% of the time in their marriage, so they would have lost that 50% of the what their alimony would have been. And so for what reason were you wanting to change this from not being counted towards that 50% time to being counted to that 50% time?
The reason for that is because we want the temporary alimony to be temporary and not counted toward any other alimony. It's just temporary until the judge can make the court can make its determination as to whether this person should get alimony or should not. And this is really more about the not creating irreparable economic harm to either side.
Thank you for your clarification. But the language that I'm specifically referring to is such alimony shall not be counted toward or subject to the duration limits of RSA 458 19A Roman 3. But you're changing it to it shall not be subject to the duration limits. So in fact, you're actually saying that that it's not going to be, it can be counted towards it, and it the duration limit can even be longer than the current one.
Well, it depends upon how long the court takes to determine the final divorce. And that was part of the reasoning there. We know that going to court for your divorce is taking longer and longer, and it could take more than 10 years.
So is it my understanding that you would want all of that 10 years of temporary alimony to be going against their 50% of the length of the marriage? So if they were married for 20 years, then after the 10 years and they finally get divorced, they would actually be done with alimony in that case?
Unless the party would be economically aggrieved.
Okay, thank you. Thank you for that
You're welcome.
answer. Any other questions? Okay, I will adjourn the hearing on HB 1305.
You're going to close it.
I close the hearing. Adjourn. It's the same. Thank you.
So I received a message from Representative Rice that she is detained in a meeting, and she has asked me to convey to you that we are going to be rescheduling, as she said in the beginning of today's hearings, House Bill 1278 relative to the modification or termination of term alimony to a date certain of February 8th. Also, House Bill 1431 is canceled and will be heard on February 8th. And with those two announcements, that means that our business is concluded for today. So I will close the hearings of January 25th and wish you all well and have a good week. She's coming up for caucus. So please stay in your seats for, oh, the Republicans can stay in their seats for caucus. Well, I guess. Of course. No, you're, by all means. Can I help you? No. We're done for the day. Thank you very, very much.
You go home now, Beth.
Yes.